The following program is suitable for general audience of any age.
Tonight, we discuss key legislation surrounding finance and leasing in Sri Lanka. What are the key instruments to be knowledgeable of in relation to monetary transactions of this nature? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is something that we have briefly touched on when it comes to technicalities in the past, but we really haven't gotten into the practical context of it, and that's on finance and leasing, and specifically the legislation that's surrounding this area, what exactly the common person needs to know and understand when it comes to grappling with this kind of law. To speak about this, we have someone that's not a new face on the program, and we're very glad to welcome back. Thank you very much for taking the time, Mr. Priyantha Alagiyawanna, attorney at law. So really appreciate you coming back to the studio in this new year to do another program with us.
Thank you, Anuradhi.
A bit of an introduction. Of course, Mr. Alagiyawanna, as we have mentioned before, has a Masters of Law at the Kotalawala Defence University. He has over 23 years of practice and mainly focusing on civil matters as well. Previously, we had him to speak about Parate laws also. So we are in a good context when it comes to talk about the financial intricacies of the law surrounding leasing and finance. Here's how we're going to be getting into the topic. First, we'll be understanding the basics and the fundamentals. What exactly constitutes financing and leasing? Next, we'll be getting into the practical context, what exactly are the key hurdles that individuals need to look out for when it comes to grappling with this law, and finally we'll be talking about the future of finance and leasing laws in Sri Lanka, what we can expect as reforms and amendments, and what it looks like in comparison to the world stage.
Hello, my name is Salman and I'm a digital marketer. My question is on fundamentals. What are the laws governing finance leasing in Sri Lanka?
All right, well, without any further ado, let's get right into this discussion. Once again, thank you very much, sir, for taking the time. I believe there's a lot of intricacies that we can get into, but it would be essential and beneficial for us to understand the context and the foundation of financing and leasing. If you could help us understand in Sri Lanka's legal terms, what exactly constitutes as leasing and finance, and how exactly does that differ from loans and other kind of financial support systems?
Yeah, good evening and thank you very much for inviting me once again. So finance leasing, basically finance leasing business, it means basically business of investing money for the provisions of equipment, so in order to carry out a finance lease. So finance lease, of course, with the Act number 56 of 2000, the Parliament has regulated the procedure by enacting the Finance Leasing Act. However, the finance lease it has some history behind it. It goes even back to the date of the industrial revolutions, and that was the time basically finance leasing started. So at that time, in order to carry out the business of coal mining, certain investors, businessmen, used to finance certain like carriages so that they can carry the coal to the intended destination to the railway tracks. So that's the history. Through that, slowly it has, of course, developed. Then in this last century, it rapidly developed throughout the world, and because intrinsic nature of the finance leasing. So what happened before 2000 in Sri Lanka also, starting from Bank of Ceylon in 1970s, thereafter some finance companies, there were two in fact, major finance companies in collaboration with some foreign investors, they engage in the business of finance leasing. So what happened thereafter in the 2000, by enacting Act number 56 of 2000, this law pertaining to this finance business regulated. It was regulated. Now what is finance lease and what is the finance leasing business. As a starting point, in the finance lease transaction, there are mainly two parties, the lessor and the lessee. The lessor give on lease the equipment which is tangible equipment for the purpose of use, exclusive use by the lessee for a payment of consideration, the installment of money. So the lessor provide the equipment through a supplier so that the lessee exclusively can use and possess without any disturbance by the lessor for a payment. That is the finance leasing. So the finance leasing business is, of course, as I told earlier, is an investment of money for a equipment for the purpose of entering into the finance lease. So why finance lease is important? Because when it comes to the market, there are various products. So you ask me about the loan transactions, hire purchase transaction, and of course we are talking about the finance lease. So in the finance lease, the ownership is with the lessor. However, he permit for a consideration lessee to use the equipment. It's basically concerned about the equity. Because when it comes to the money, a capital has to be there to enable the business institution to carry out their business. So if you intend to purchase a vehicle or other equipment for the purpose of your business, you must have a sufficient capital. When you reserve a large amount of capital for that purpose, you will not be able to carry out your day-to-day business. So in order to compensate that, what has happened by this finance leasing, you pay only a rental. Monthly basis, you pay the rental. So your core capital will be with you, so you can use it for other businesses. And here, periodically, you have equipment to use for your purposes. At the same time, your money also with you so that you can put it to a other use which is beneficial to companies and the individuals. So how it differ from the other aspects? So hire purchase, when it comes to the Consumer Credit Act number 29 of 1982, the hire purchase are regulated. So as indicated and as set out in that act, so the difference is under the hire purchase, you have at the end of the day have option to purchase the vehicle. You can purchase the vehicle. Here, under the finance leasing, there is no such a scenario. Loan transactions are concerned, ordinary transactions are concerned, loans are given, of course, for specific purposes, but it is not tied to up to a equipment. What has happened as given by the definition under section 43 of the Finance Leasing Act, when it comes to the tangible assets, save and except the lands are excluded, of course, finance leasing are applicable. So I think that's a starting point.
Yes.
We can move on.
Exactly. I think moving on as well, so now you mentioned how it differs from other instruments that we can use in order to support financially. But when it comes to finance leasing, apart from the act that has already been introduced, are there any other tertiary pieces of legislation that is considered when it comes to these laws, or is it simply everything is enshrined in just one act?
Yeah, because prior to 2000, law regarding this was governed by our common law. There were no piece of legislation. So as stated in this act, in the preamble, this act was enacted to provide for regulation and monitoring of the finance leasing business and to specify the rights and duties of the lessor and the lessees and the, of course, in the suppliers of the equipment and the matters connected and incidental thereto. So then as per the preamble, it It is very clear what the legislature wanted was to consolidate the law regarding the same and bring an act of parliament so that parties to the contracts will be governed by these laws, because as per our law, no one can contract outside the statute. You are basically bound by the statute, save and except there are a few exceptions in this act, which of course say that certain sections can be excluded. So in short, it was the common law which was there before 2002, 2000 rather. Then the parties used to enter into agreements. Then the privity of contract is important in such a scenario. Then parties are bound by that condition of the agreement. If they breach, of course, they can resort to court of law. However, the legislation are concerned, only the Act number 56 of 2000 is applicable at present.
Right, understood. And you mentioned previously as well, sir, relating to licensed finance companies. Can you help us understand what exactly constitutes as a licensed finance company in Sri Lanka? What are the key features of it, and is it well detailed in the Act in itself?
Yeah, this is also, though this Act has not been termed as a special law, when you look at the Act in totality, it is very clear that this Act is also applicable to the specific persons, a class that has been defined under the section 3 of the Act. So in Sri Lanka, only the registered finance leasing establishment as registered under this Act number 56 of 2000 can engage in the business. So what are they? The section 2 has defined without certificate of registration, no one can carry the business of finance leasing. Then the section 3 has set out the persons who can carry on the business of finance. Those are licensed commercial bank, licensed specialized banks, and then the finance company which you adverted a moment ago. Then of course the public company, PLC company. So finance company, this Act say finance company within the meaning of Act number 78 of 1988. Of course now business of finance is regulated by the Act number 42 of 2011. So under that, in order to carry out the business of finance, especially to accept the deposit, there are certain requirements which must be complied with, especially regarding the capital requirement, assets and everything. So once you complied with those requirements, a license is obtained by the director from the central bank who is in charge of this finance company only, they can carry out the business. So that is applicable for this Finance Leasing Act also. This must be modified to say that a finance company registered under the Finance Act as well as the Act number 42 of 2011 I mentioned. So what does it mean? It means lots, because these institutions, if you take a bank, PLC company, public listed companies, and the finance company regulated by the central bank, they all are overseen by their master, the principal, the central bank. So they are regulated. So what happened prior to 2000? They have an unregulated business of finance leasing. What the legislature has done, they have brought under one umbrella and established a mechanism where only limited class of people can engage in the business of finance leasing.
So it's very essential that we had clarity when it comes to that context as well, to ensure certainty and trust in institutions that deal with the monetary support as well. Sir, before we go into a break, a very curious question before we get to the practical context of what individuals should look out for when it comes to these contracts. I want to ask you relating to the ownership of whatever instrument or material that the finance leasing is going to occur on. Now, you mentioned previously as well that ownership is not transferred through this kind of contract. How exactly does the law distinguish this kind of issue, specifically when it comes to very long leases, finance leasing? because it always blurs the line at some point, and there will be some sort of issue relating to who exactly will be considered the owner of that instrument.
Yeah, you see that as the word denotes, this is a finance leasing. When it comes to the leasing, the ownership never changes. And all the concept is based on that. Because the lessor always remain the owner. However, when it comes to, if you take a vehicle, there is an absolute owner, that is the lessor, there is a registered owner. But as far as rights are concerned, the rights are vested with the absolute owner. Of course, the registered owner is entitled, as per the section 11 of the Act also, undisturbed use and possession of the equipment. So, since it is a lease transaction only, the ownership is always remain with the lessee. That is where the difference lie when it comes to the Consumer Credit Act of 29 of 1982. At the end of the period of the hire, you have options to purchase it. You can purchase it. Here, however, interesting thing, under the interpretation, section 43, of course, it has stated that the law has been enacted to say that, notwithstanding what is stated in the Act number 29 of 1982 also, even under the Finance Leasing Act, it is possible to, at the expiration of the initial period, basically to come into agreement to transfer the ownership of the property.
There are certain situations
property
that allow for it.
Yes, because it say which is though not a hire purchase agreement within the meaning of the Consumer Credit Act. So still it is possible for the purchase of the equipment.
There is a specific clause.
Right.
I want to get to the practical context as well, so where individuals should be looking for specifically when it comes to what exactly is mentioned in these contracts, and to prevent any sort of predatory behaviors as well. As much as the Act has tried its level best to ensure a safe and level playing field, there's always issues that individuals should be keen about. Before we get to those specifics relating to the practical context in which this law applies, we do have to go in for a short commercial break. We'll see you on the other side. This is Law, Land and Liberty here on Other Derana News Channel. Stay tuned.
Hello, my name is Gailis Kandakumar. I'm a public policy student and a social activist. My question is on practicalities. What are things individuals should be vigilant about in this area?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Priyantha Alagiyawanna, attorney at law. We just got done discussing the first segment relating to the fundamentals of finance leasing and the legislation surrounding it in Sri Lanka. Thank you very much, sir, for the previous segment. I believe we covered as much of the fundamentals as possible, and we got to a very important point where we were trying to understand the distinguishing between ownership when it comes to different contracts, specifically when it comes to finance and leasing. And now, when it comes to the practical context that this law applies in, there's always a question of what exactly individuals need to be shrewd or keen about when entering into this kind of agreement. What are some key clauses that you can understand with your practical experience as well, sir, that individuals should be very wary and diligent of checking when it comes to these kinds of contracts, specifically when it comes to finance leasing?
Yeah. Yes, unfortunately for the borrower or the person who take the lease, the lessee, most of the agreements are standard format agreements. So only difference are found in the schedule. The schedule is filled. So what happened, as we have earlier learned, now when it comes to the finance leasing facility or any other facility, it's something to do with your ability to repay the money. So as far as the time period which you want to take the whatever the equipment on lease and your repayment capacities are concerned, then having regard to those facts, you have to agree on the installments. So what happened under finance lease, a capital investment is done by the lessor. The lessor expects that to be recovered along with the interest, cost and other charges, because they recover the charges also and the other VAT etc. for and on behalf of the government also. When it comes to the lease rental, everything is included. You have to see within your capacity what is the amount I can pay and what is the period I can pay. And basically other clauses are concerned, those are standard clauses. Then what we should be very careful about when it comes to the finance leasing, the acceptance of the goods. So there are three parties to this contract really: lessee, lessor and the supplier. It's a supplier who is obliged to supply the goods in accordance with the warranties, conditions and the specifications. The problem is, once you accepted the goods, the contract is completed. You can't go back on it. So we basically, now the issue arises when we are using the equipment, there could be a problem. But the rights of the parties are concerned, it is very vital. The lessee, of course, inspect the goods and acknowledge the goods only after having satisfied with the supply agreement. Because the issue is, once you have accepted the group, you can't go back. You have to make the payment as per the agreement. Now, that's the leverage given by this act also, because if you non-deliver the goods, if there was a late delivery and if it is non-conformity with the supply agreement, you are not obliged to go ahead with the agreement. So that's a legislature has given some relief to the lessee. But once you accepted the good, of course, agreement come into force and you are duty bound to do that. So those things we have to be careful in the practical scenario. Acceptance of the good. Then the lease rental, etc. The issue is, if you agree upon the lease rental and if you make the lease rental, if you make the repayment of the lease rental promptly on due dates, there will not be any issue, because none of the conditions as contained in the agreement will come into operations. The problems start when you default only. And that's where the various conditions in the agreement will become operative and act against the lessee. Because you see, the lessor has invested some money with the anticipation of obtaining or recovering it along with the interest. So on the other hand, lessee accepts the goods, he uses it without any disturbance. So there is a two-way process. So in order to strike a balance, what the legislature has done, they have set up two stages. Stage before the acceptance of the equipment and after the acceptance of the. And so the problem is, most of the contracts are standard clauses contract. Virtually the lessee has no say. That we have to admit that.
So the fact that you mentioned that a standard form contracts is what applies in most situations, specifically when it comes to finance leasing, can you tell us if there's any practical situations in which there were negotiable contracts, or is it simply only standard form that we see? Just a quick clarification before we move on.
Yeah, I must say hardly any, because the reason is this standard type of contracts have been formulated and drafted over a period of time to cover given any situations. However, I must say that those contracts like section 11 and 12 of the Act, the duties and the obligations of both the parties and resultant positions and everything are set out usually.
Right.
So it's highly unlikely that there will be a room for negotiations, because they also, these are somewhat, as far as the lessor is concerned, lessor is in somewhat superior position, and then they use the standard format. And of course, as I mentioned earlier, installment etc. can be negotiated, and you can agree on that to suit your requirement, probably not the substance of the contract.
Right. So the fundamentals will remain as set out in the legislation, but of course the specifics relating to the object.
Usual contract contain the details as to the ownership of the property. So what will happen in the event of default? So what are the rights of the lessor after termination, repossession, recovery of arrears, recovery of money due for the even for the future periods, and how the lessee should look after the vehicle, and those everything are basically are there in the contracts. So therefore, lessor will be very reluctant to change it.
Yes.
Yeah.
Of course, there is a bit of preference towards the lessor, of course. Now, what you mentioned very importantly as well, as it is set out in the contract also, so I want to ask you relating to repossession, how exactly the law governs this specific area. What does it look like in current legislation when it comes to this specific act, sir?
Repossession or recovery of possession of the vehicle, it triggers on two occasions. One is that after the expiration of the agreement, there is a time period. After the lapse of the time period, the lessor is entitled to take the vehicle back. So is the after prior terminations. So prior termination, of course, is possible under the section 20 and 21 of the Act number 56 of 2000. So first you have to give the notice of substantial failure, specifying the substantial failure in complying by the lessee mainly to make the payments, and giving him at least 1 week's time period to remedy it. That's under section 21. So if the lessee fail to remedy the substantial failure, you go back to the section 20. Under the section 20, you can demand as a lessor, demand the lessee to make the accelerated payments. So in the event accelerated payment is not complied with by the lessee, the lessor is entitled to terminate the agreement and recover the possession of the equipment. So even under section 15, it is clearly stated that upon the expiration of the agreement and no prior termination, the lessee, if the lessee failed to return the equipment, the lessor is entitled to recover the possession of the equipment. The many issues arising usually in the manner the vehicle is or the other equipment taken into the possession, or possession is taken back by the lessor.
Yes, that is one of the areas where individuals end up splitting hairs, specifically related to the procedure and the process of repossession. A very curious question that we have specifically relating to repossession, sir, does Sri Lanka's current legislature require a notice to be sent out before repossession? As you mentioned, notice of substantial failure is one where you mentioned that the terms of the contract has not been upheld in the manner that is necessary. But apart from that, are there any sort of other notices that are sent out to the individuals in current possession, or what exactly does that?
So there is no legal requirement to send such a notices. So as long as the customer make the payment promptly without any default, the lessor is not entitled to terminate the agreement or take the equipment back. So if he does that, that will amount to a violation of the terms and conditions of the contract. Maybe he can be sued even for damages. The next questions arises, what happens if the lessee make the default? When he make the default as per the agreement, as per the law also, the company or the lessor is entitled to recover the possession. So the vehicle is in illegal possession of the lessee then. then law has mandated, of course law has permitted the lessor to take the possession with the assistance of the police by section 27 of this act. So in such a scenario, if the lessor feel that possession could be taken without any resistance, the operative words are without any resistance. So with the assistance of the police of the area, they can recover the possession. So that is the point where many issues are arising in the practical sense. So there are many people will be reluctant to return the vehicle. But law mandate that when the vehicles are in the legal possession, the lessor is entitled to take it. So how to strike a balance? Now what the legislature has done, they have put the word in that the without resistance from the lessee. That shows that if there is resistance, the lessor is not entitled to take the possession itself, then it has to seek the assistance of the court. The assistance of the court can be obtained by resorting to section 28 of the Act. Section 28 of the Act permit the company or the lessor or the banks to obtain the delivery of possession of the vehicle by an interim order. It's like akin to a summary procedure where you file a petition, set out the facts of the default, and move the court to make an interim order directing the lessee to deliver the vehicle. So in such a scenario, the law provides, section 29 provide, even other money due under the lease agreement can be recovered. So then the lessee has to show cause as to why this application should not be allowed. So that is the mechanism there. Voluntary handing over, of course there is no problem then. Then if the company feel that of course there will not be a resistance, they can take the possession. Then if not, you have to resort to the section 28, and also regular actions are being filed. So at the by filing the regular actions, while asking all other remedies, the companies, the lessors also ask the remedy of return of the vehicle or the value of the vehicle or the equipment, as the case may be.
Right.
So, yeah.
Exactly. I want to get into a little bit more on the specifics about how the rights are balanced between the customer and the company, specifically when it comes to these kind of disputes and situations, what remedies are available on both ends. As you mentioned, this was some of the remedies that were available for the company in itself, how they can allocate for repossession. There's certain clauses that are available, but we also want to get to the flip side of the coin, where if there's any sort of unlawful possession that's happening, how exactly the suing for damages will occur. But before we do any of that, we do have to go in for a short commercial break because we are out of time in this specific segment. Please do stay tuned. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back.
Hi, I'm Andrea Silva. I'm a civil engineer. My question is on the future. What can we expect as developments in this field?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Priyantha Alagiyawanna, attorney at law. We just got done first two segments relating to finance leasing and the legislation surrounding it. Thank you very much, sir, for the previous two segments. Unfortunately, we are running out of time. This is our final segment, but we left off on a very important area, specifically relating to repossession. What exactly happens when there is an issue when it comes to the continuance of the contract of finance leasing? Can you please help us understand, sir? Now, previously you spoke about how exactly a company can resort to recovering damages that are done through the customer that may not be allowing for an undisturbed repossession of the item or the material that has been in contract with. But what exactly does the flip side of the coin look like, specifically relating to the customer, sir? As you mentioned very briefly previously as well, when it comes to unlawful repossession, what are the remedies available for customers?
So if the customer make the payment promptly without any default, the company, the lessor, is not entitled to take the vehicle back. If they take so, it's an amount to a breach of the contract. So they can be sued for damages in the district court, and of course vehicle can be taken back. What happened really in practical scenario, the repossession mainly is taking place when there is a default. That's where the resistance and all the scenario arising. What happened in the practical sense, then there will be complaint to the magistrate court regarding the unlawful repossession that is basically covered with the other allegation like a theft, etc. People say there was something in the car, it was taken up, that sort of things are happening. But it's not really the issue is, now if the vehicle is in lawful possession, of course there is a real question, lessor can't do anything. If it is an unlawful possession, there will be an issue whether a damage can be awarded, even if it is taken possibly. Because vehicle, the absolute ownership is with the lessor. And then the court also will be reluctant in such a scenario to intervene, because here a man who comes to the court also at fault. And however, from time to time there are circulars issued by the government, etc., to regulate this conduct. But the law mandate that with the permission, when there is a breach of the contract, when you are entitled to take the delivery back with the assistance of the police, you can take it. So everything depends on whether you are in default or not.
Very important point that maybe individuals would want to understand, sir, is the level of interest rates and other fees that finance companies can actually charge, specifically when it comes to customers that are coming to enter into such a contract. Can you tell us if the law states that there are caps on interest rates to prevent some sort of extortionary nature of these contracts?
So all these lessors, as I stated earlier, they are regulated by the central bank. Then when it comes to their markup, etc., there is a fixed rates for leasing business also. Therefore, they can't obtain any unconscionable profit. The interest rates and everything are agreed upon at the outset. Therefore, when it comes to the installment is concerned, the capital spend, interest component, other charges, all are coupled all together. Accordingly, in 48 months or 60 months, you are supposed to make the installment or the repayment. If you make the prompt installment and the repayment, the lessor is not entitled to charge any overdue interest or the penal interest. These conditions, this agreement contain a conditions in case of default, the lessor is entitled to charge overdue interest. That could be avoided by making the prompt payment. When it comes to the overdue interest, there is no bar in the law due to privity of contract to charge in the overdue interest. Only bar is the civil law ordinance, where it bar recovery of the interest in excess of the capital. What happens when you obtain the finance leasing facilities, it is repayable over a period of time. In more often than not, as time goes on, even the interest component exceed the capital. So then the civil law ordinance may come into the post. I must say that this legal issue has not been authoritatively decided by the courts of this country. On the one hand, there is a privity of contract. Parties agree to pay the interest at particular rates. say 20% for a year, after 5 years it's 100%. So however these caps are there, then we have to wait and see how the courts will interpret a scenario like this. But you see that penal interest and the other hidden charges, etc., of course there is a regulator. Every act of the lessors under this establishment are monitored and regulated by the director who is in charge of this business, appointed by the central bank. The director or his representative is entitled to inspect the books, accounts, and take a note of it and make investigations. As per the section 8 and 9 of the Act, the director even can suspend or cease the operations of the finance companies by doing this finance leasing business. So it's not a one-way process. Only one hand, the legislature has permitted the party to contract. On the other hand, their conduct, the lessor's conduct, has been regulated. They are supervised. So I don't think they are entitled to charge unconscionable interest because of that. One is because of the privity of contract. On the other hand, because from time to time also, when it comes to the even leasing facilities, central bank of course issue the circulars in these days after the impact of these economic issues and also COVID-19 pandemic, etc. Central bank from time to time indicated these are the rates which must be charged when it comes to the leasing facilities and other financial facilities.
Yes, very important question that I want to build on a little bit before we go into the final few discussions. Sir, relating to the transparency of these financial institutions, as you mentioned, there is a regulator that helps keep in check. In your opinion, do you believe that this process looks transparent enough in order to ensure that malicious activity or extortion will not occur, especially unconscionable specific areas, or do you believe that there is a need for more transparency in this?
So if there is a change of the rate of interest or other charges, it is best that it must be notified to the lessee, because these facilities are obtained not only by the influential segment of the society, by ordinary people also. Then they must be told for these reasons these charges will be added. What happened? These charges basically payment due to the government in the form of taxes, etc., insurance payment, repossession charges, and those things are the charges which are accumulated. All these things happen, unfortunately, save and except the insurance fee, after you are in default. So then, as per the agreement, they are entitled to charge those things. The problem is there are no, unlike in the Consumer Credit Act of 1982, there are not much safeguards when it comes to the Finance Leasing Act to the lessees. That situation must be addressed inclusive of repossession. The repossession also is a two-way process, because sometime what happened, by the time order is obtained under section 28, vehicle goes missing. The lessor cannot recover the vehicle. On the other hand, if possible disposition of the vehicle or taking back of the vehicle is happened, that must be addressed by the court of law and by the legislature, given sufficient power to address those issues also, because it's a matter of concern. I think high time we look into that aspect. Now, there was a demand by the general public to hold this process during the pandemic. However, what is important thing, when it comes to the lessor spends certain amount of money, he make an investment and permit the lessee to have a benefit of the investment of the lessor. So we have to safeguard the industry as well as the lessee.
So we have to have a proper balance as well.
Proper balancing act.
in order to ensure that the action should not occur following default or following the loss of some sort that being incurred to either party. Unfortunately, sir, this is all the time we have when it comes to discussing this specific area. I believe we could have gotten into lots more of the specifics, but thankfully we were able to cover the fundamental aspects, the foundations of law when it comes to finance leasing. Thank you very much for your time, sir, for coming to the studio today to help us understand this topic.
Yeah, welcome.
All right, well, we'll leave you tonight with the words of Jean Locke. Our incomes are like our shoes. If it's too small, they gall and pinch us. But if it's too large, they cause us to stumble and trip. That's all we have for you tonight. You can always rewatch by catching us on our YouTube page. And we value your opinion as always, so please share your thoughts and feedback with us through email at feedback.adncenglish@derana.lk or by WhatsApp at 076 805 7933. Thank you very much for watching. Have a great night.